Are we good? Duncan. And good evening. The Washington County Quorum Court is now called into session. I think we got a couple more chairs, okay. Well, good evening. Glad that everyone is here. Kind of the fall is here. The weather's changed. It is really on the holidays of next week, and it's all in. Our elections are over. Congratulations to all those who won, those who got out and participated. Appreciate all the work in our election commission and election team. We're going to go ahead and get started. We've got a pretty full agenda. J.P. Duncan, will you go ahead and lead us in prayer and pledge?
Father God, thank you for Christ Jesus and his perfect life and death on the cross for our sins. God, thank you for government, the institution of government, and the opportunity to lead and make decisions on behalf of constituents and citizens of Washington County. God, I pray for wisdom tonight for myself and for the court. God, I pray that our decisions honor you and bring you glory. We pray all this in Jesus' name. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, J.P. Duncan. All right. Adoption of the agenda. J.P. Lemming.
I need to add resolution item 22R-010.
Everyone should have had that at their table. So that will be, so we got a motion to add a resolution to the agenda, second by J.P. Dennis. All in favor? Aye. Those opposed? All right. That will be item number 16. How's that? Item 16, resolution. Is the Everett family here? Are the Everett family here?
If they're here, I was going to suggest we let them go.
Are they here? I didn't see them come in. Okay. All right, thanks. So that'll be item number 16. All right, adoption of the agenda as amended. We got a motion, a second. All in favor? Aye. Those opposed? All right, we have the adoption of the agenda. Preliminary motions. This is what we ask. We'll read. All right, J.P. Deakins.
Thank you, Judge Wood. I move that we read titles and ordinances and resolutions by title only.
All right, we got a motion and a second to read ordinances and resolutions by title only. Second by J.P. Lemming. All in favor? Aye. Those opposed? All right. Preliminary motions are taken care of. Citizen comments. This is where we ask citizens to come forward, tell us what's going on in your area. Ask you to tell us who you are, where you live. You'll have 3 minutes to share that with us, a total of 15 minutes. But at this point, we'll ask you to come forward. Citizen comments. Citizen comments. All righty. All right, approval of the minutes, item 6. Approval of the minutes. Any corrections, sir? J.P. Duncan?
That's approval of the minutes.
We got a motion to approve the minutes. Second by J.P. Was that Wilson? All in favor? Aye. And those opposed? Abstain. All right. Minutes have been approved. County judge report in your package. You should have your disposal report. Also want to make sure, I apologize for not saying it early enough. The extension office, anybody in the extension office here today, this morning, this evening? No? They already left. But again, they brought goodies in for the court members. They did make sure that we had a great celebration last month with the 194 years of Washington County being here. I thought I said it last month. I want to make sure I say it again. We cannot do what we do in the county with our extension office. So again, hats off and thank you to our extension office. And again, thanks to all our supporters, our election workers, poll workers and watchers, our election commissioners, our county clerk and their office. Thank you guys for pulling off a pretty robust election last week. And to all our new members of the court, welcome. To our outgoing, we'll be doing something next month. But again, what a great election season we just came out of. So I think Springdale may be doing a runoff sometime next week. So anyway, with that, that's the judge's report. We'll move on to item 8.
I was just confused on the property report. Are
Madison.
the numbers, like it says IO and it has a number, is that different from, I don't know how we're supposed to know what it is if it's just a number.
I gotta look at it. I don't know what it is. Let's see. Is that the control number or well, I don't know, the item number?
Yeah, those are they're tagged and they're given, everything's given a
When,
number.
Well, there's 3 items and there's 4 numbers, so I just don't, I don't know.
let's see,
Well, one Del Monte quantity.
it's 2.
Well, but there's 4 numbers and 3 items. That's what I don't understand. Okay, well,
Fine.
it might be better to have more helpful descriptions. Thanks.
Thank you, J.P. Madison. On the item 8, salary program discussion, at our quorum court last month, we were going through our salary discussion. The court stopped and asked us, hey, with the number of back and forth and adjustments, will you guys as elected officials get together, agree to a plan and get that back to us? We as elected officials got together, worked through about 3 different plans, came up with a plan, and got that to you guys, which is in your packet. There was a Scribner error that you guys got in there in your packet today, 2 employees that we did some modifications, so you have that. I think we were also something from one of the judges, Judge Lindsay. Counsel, will you remember that one? What was that one?
Yeah, so after the meeting, I believe Judge Taylor reached out to HR and requested an increase on her law clerk for various reasons. And that was done directly with HR. And so when these numbers came out, her law clerk is at quite a bit higher than Judge Lindsay's law clerk, and Judge Lindsay saw that. And so he's requesting that they be the same. Now, whether they both be at the higher number or the lower number, that, certainly is up to you guys, but there was a discrepancy. They're the same exact positions for 2 different courts. And so he just reached out when he saw that.
So with that, that is now our time now to go through your salary discussion. And with that, the floor is the courts. J.P. Madison and then J.P. Hires.
I know at some point we got an email saying send it to us, but we never got it. So this is the first time we've gotten it, is tonight?
No, went out with the packet. You got it last Friday.
Okay. Okay, but we didn't get it when, I know I think it was J.B. Eckey sent an email to all of us that said send this to us, and then I kept waiting for it to come. Okay, well then, my question is, I know there was sort of these competing proposals, the HR proposal and the assessor's proposal, and then I understood that there was kind of a hybrid. What are we getting?
So what you have is the hybrid, which is a blend of the HR, it's HR's proposal with 5 amendments from elected officials to say, yep, we would really want to have these changed on there. So that's what all the elected officials agreed to.
And so we have, so it sounds like HR proposal for the county judges' offices, which was based on a job title comparison to Benton County, right? Mm-hmm. Okay. And then we have the assessor's proposal for the other elected officials' offices, and I assume also for the judges' positions in juvenile court? No. Okay.
No. Just 5 electeds.
Okay. And what's the rationale for that?
Well, it was, again, the charge was for the electeds all to get together and agree to something. Assessor Hill's plan was not a plan that everybody can agree to. The HR's plan, which was reduced, the original plan had everyone at, I don't know, looking at market like Benton County, it was much higher, and the court asked us to reduce that. We did reduce it for everybody in the entire county. The elected officials who had challenges, Assessor Hill and the other 4, did not like that, and they came back and wanted amendments to it. Those amendments were put into the plan. So that's what this plan is. It is the plan that all the other elected officials, Judge Zimmerman and myself and the sheriff, everybody else agreed to everyone agreed to the plan that's presented in your packet.
Well, I'm glad everybody agreed to it. I'm trying to understand the rationale for the pay increases. What was the methodology for, we know that Patty Burchett's method was to compare job titles. So if there was a job title in Washington County, she compared it to Benton County and made a match. And there was some question as to whether that was a valid comparison, but that was the methodology. And so I'm interested to know, for these other elected officials that have come up with numbers they agree on, what was the methodology? I mean, there has to be some rationale for how, for instance, the assessor didn't like the first proposal, so he proposed another. What was the methodology?
Assessor's not here today.
No, I know he's out of town. He had to go to an event tonight. But I'm trying to understand my employment lawyer brain is really wanting to make sure that we've done a valid methodology for how we're setting pay. And I've yet to really wrap my head around, I mean, if everybody just went in and said, hey, I'd really just like to make $10,000 more, and that was the methodology, okay, well, we can evaluate that for its soundness. But I'm having a hard time being asked to give very healthy raises without understanding the logic behind them. So, I mean, because all we got is numbers. The spreadsheet is just numbers. We don't see like where they were or a change in grade. It's just a proposed grade and a proposed salary. So let me ask one more question, Judge, and I'll yield the floor. What is the total additional cost?
$2.2 million.
So this would increase the existing budget $2.2 million.
That's correct. And that's all in taxes, APRs, all the benefits, et cetera.
Okay, thank you.
JP Hires and then JP Dennis.
Thank you, Judge. I'm also struggling with things just a little bit because it was my understanding. I walked out of this meeting thinking that we had requested that the court call a special meeting so that we could all go over this before we were here in front of the public ready to vote. And so we never did get that special meeting. That was what I walked away with, that understanding. And so I'm kind of struggling with this because I thought that we would get together and have a special meeting so that we could go over these numbers and discuss that, and that never happened. So just throwing it out there, that was part of what I walked away with. Thank you.
JP Dennis.
Thank you, Judge. Being on the Personnel Committee, the thing that I wanted to bring up or want to ask and have it on record, we didn't take it through the Personnel Committee and we didn't take it through the Finance Committee. But yet, so are we clear on that? Are we legal with what we do? It's just a question I have being on the committee. I want to be sure that.
I would say yes. I don't know if you have any more to add to that, Attorney.
Well, I know that Ms. Meyer reached out to the chairs of both of those committees to set those agendas, and both chairs said that they would prefer that it not go to their committee and they not have a special meeting for that it come straight to the Quorum Court. And that was exactly what was said. Because she reached out to both of them, and so that's why it went to the Quorum Court.
So, I mean, when you follow if someone's dotting the I's and crossing the T's,
That's correct.
We're correct on what we're doing?
That's correct.
Okay. I guess the other thing I want to say, and I want to say it because I don't want to be guilty of thinking it and not saying it. I like the idea. I want the employees to have good raises. If I took my bottle of water and I just put a little bit of poison in it, and then I got real thirsty, and I said, well, I'm going to drink my poisoned water. It's just got a little poison in it, though. And I drink it because I want water. Well, I want the employees to get raises, but I see some things that just don't look right.
Don't drink poison.
And so don't drink the poisoned water. So I'm having a hard time with that.
And I've talked to a lot of employees, and they say, well, you know, I understand where you're coming from, but we want our raises, and I want them to have their raises. But, so how do you correct things? There's not a method this way to say, well, I don't think this is correct. Or do we make amendments to it? And that would just take a long, long time to go through and everything that we saw, change each individual thing that we didn't like. And of course, you know, we could open Pandora's box and be here all night long talking about salaries. And so I really think it should have gone to personnel, and we could have knocked out things that we didn't like as a legislative body. That's what we are. And I feel like we were left out of the process because I didn't vote on it, and I'm on the personnel committee. And so I'm just one step away from saying, let's table this until next meeting and have a personnel committee and a finance committee on it so that we can put our stamp of approval or stamp of disapproval on it and then come back to the full quorum court with a recommendation.
J.P. Wilson.
Thank you, Judge. I just had a couple of questions. I wanted to ask the chair of the Personnel Committee if they've had a chance to review this and if they're satisfied with what this product is.
J.P. Hickey.
No, I'm not. And I'll say that because this did not follow our JSAP, which is our Job Evaluation Assessment Program processes. I asked if there was any controls to the proposals. There are not any controls. It's going to be done through JSAP. When you look at the Personnel Handbook, which is ordinance, and this is what we follow. You go to page 37. It's process for submitting a PADQ, which is a position analysis questionnaire by elected officials or department heads. Number 5, it talks about a copy of the job description to county's compensation consultant, who is a third party, will then review and rate the job based on the JSAP/DBC compensation job evaluation. Number 6, the county's compensation consultant will present new job descriptions and significantly revise positions descriptions, recommend job ratings and summaries. Number 7, then it will be presented to the county's personnel committee and then through the county's approval process, finance committee and quorum court per policy requirement. It will be prepared in a job description and schedule it on the agenda for the Job Evaluation Committee. Has to review it first. A newly created position should not be filled until the job has been properly described. We did not receive, what we have is two different proposals. You have 5 elected officials who say we have a salary adjustment comparing our salaries with Benton County. You have another proposal that is jobs and titles, which was regraded and which didn't go through JSAP. The regrading needs to go through JSAP. That's the legal process of the county. There wasn't a description or a letter of justification submitted to JSAP or the personnel chairman, where I am, saying we are going from grade 17 to grade 26, and this is a reason why. These are my justifications. I didn't receive anything like that. When I thought it had gone through the proper JSAP processes, and I apologize, I got the flu the Saturday before the election. So by the 10th, when we should have had the meeting, I was home, sicker than a dog. So I chose, no, I can't have a meeting, no. But there aren't any controls, but there's supposed to be JSAP controls, but we're not following them. So I do not feel comfortable in passing this on for tonight's approval. Now, I do want to say, if I may, Judge, because I am personnel chairman, I want all the county employees to know we will give you a good salary adjustment starting in 2023. We're not going to drop the ball. We're not going to pass it on to another court. It will be passed, but it will be done legally per ordinance and our handbook. So don't get worried. Don't fear. You're going to have a great Thanksgiving and hopefully a great Christmas. Okay? But we need to do it properly. Thank you, Judge.
Judge,
J.P. Duncan?
The second question that I
Oh, I'm
had
sorry.
was whether the chairman of the Finance and Budget Committee had had a chance to review this proposal and if he's satisfied with it. Since we haven't had either of those meetings since we last met.
J.P. Deacons and then J.P. Duncan.
I have seen both salary proposals. The HR proposal, if you will, I guess that's kind of what we've dubbed that, we've seen here in this meeting, and then I was invited in to see the other elected officials meeting, and my understanding was that all the JPs were invited in to see that. So it's by no means keeping people out of the process. I apologize if that's how you felt, JP Dennis. And then I also want to comment, the reason I did not have a Finance and Budget Committee meeting was because I felt that this being at the full quorum court now, I wanted everybody to participate. So once again, there was no malice in that. I just figured that we should all debate it here at this level so we could all have a voice, because we've been criticized on the Finance and Budget Committee before that not everybody has a seat at that committee, and so that was my planning of that. Am I satisfied with this proposal? Absolutely not. I think there's a lot of inequities. We set out, in my mind, to make the county salary administration fair and make it move for the whole county. I think that's the only way it makes sense, right? That all the positions move together, and that way we're not competing against one of each other as elected officials. And I think we can all see very much on the front end of this salary administration absolutely accomplishes none of that. And in fact, in my mind, it makes it 10 times worse. And so that's where I'm at. Thank you, J.P. Wilson.
J.P. Duncan.
J.P. Wilson, you good?
Oh, you finished? Okay, J.P. Duncan.
So I know a few of my colleagues that made comments sounded like they were making inferences towards making a motion, but I didn't hear a motion yet. So I'll just speak my piece, and if someone wants to make a motion on this. But the total impact is just under $2.6 million. The impact to general is 2.2.
That's correct.
So every percentage point here, so 17% increase across the board. So let's pretend this is the absolute best salary proposal. Everyone is super excited about it. How are we going to pay for it? It's a $2.6 million increase. So even if it's just like everybody's excited, and then is that sustainable going forward without raising taxes? I don't think so. So that's my first concern. I appreciate the intention behind the elected officials and behind HR. It sounds like we were far behind when it comes to salary versus rest of market, and we're not able to fill roles, and we've got a whole number of issues there. This doesn't seem to be the silver bullet to fix that. We've got this meeting and one more quorum court before the year is over and there's a new court, and then guess what's going to happen? Everybody in that court's going to take 6 months to figure out where to sit, where to get a bottle of water, and then but it'll be budget season again, and this will be 2024. And they'll be trying to figure this out. I don't know that we're going to solve it this year. I have another approach. I don't think it's perfect either, but it's a thought to I'm not making an ordinance or making a motion. I'm just making a suggestion for discussion's sake with the court. If the plan in front of us is a $2.6 million ask, that means every percentage point at 17% increase, every percentage point is worth $150,000 roughly. So what if instead we gave each department a 7% increase? That's equal to $1 million for quick math. And then they were able to work within that to give raises appropriately to their departments. So said another way, employee A is doing an excellent job. They've continue to show up early. They do the work of 2 people. Maybe they deserve a 10% raise. Employee B is not doing as great of a job based on merit, based on their performance. Give them a 3% raise. As long as that totals up to 7% and each department head can live within their budget, fine. They get to actually make the decision. Or they have the easy button, which I'm afraid many will do, and they'll just give a flat raise across the board of 7% and not consider the gap to market or the performance of the individual. So 7's not a magic number. I don't think $1 million is a magic number, but that's a starting place. It's less than half of the current ask of $2.6 million increase. I'm not even sure that that's sustainable, but it sounds like we've got such a gap that we're going to have so many vacancies and the county's not going to be able to provide services that need to be provided otherwise. So I'll leave that there, and excited to hear discussion from my colleagues on the court.
JP Hires.
Thank you, Judge. So I'm just going to say again, I don't understand why we can't just call a special meeting of the full quorum court to focus on this issue. I appreciate the sentiment and the logic behind not taking this to committees that we are all not a part of. I do appreciate that. But I still think that this is too big of an issue for us to figure out tonight. I don't understand why we as the elected body of Washington County can't call a special meeting of us to focus on this and then send it on to personnel and budget and finance after we do that. I don't see why that's such a difficult ask. So I'm going to ask again that we maybe consider doing that. And I do, I knew that there was a meeting that we were all invited to, but I am a school teacher and I was not able to get a substitute to go and listen to a county discussion about salaries during business hours. That's why these hours work quite well. Thank you.
JP Johnson and then JP Eki.
Thank you, Chair. First of all, I like my colleague, Mr. Duncan's proposal. I don't know that I know the right number or the right percentage, but I sat here in that front row in 2018 when the sheriff's step plan was first passed. And my speculation was that the court that passed that did not understand that because we spent the first 6 months of 2019 talking about it. I sat here in this chair when we passed the detention step plan, and I'm not sure we all understood it. And I sat here when we passed the road department step plan, and it was said that night, this isn't the perfect plan. We're not going to find a perfect plan, but I think we owe the employees of Washington County some answer, and we need to tell them what we're going to do, because what I've learned, or what we've learned, since the road department got that proposal, yesterday they had 3 vacancies and a stack of 20 applications. They can fill the positions. Mm-hmm. The sheriff has got most of his positions filled. But when you talk to Director Tinsley, he's about 30% vacant positions in a job where he's got to man the Juvenile Justice Center 24/7. So I truly believe we could have 6 special meetings and not agree on a plan and not understand a plan. But I think we've got to make a decision what we're going to do from a salaries point and get it done.
JP Madison.
Thank you,
I
Judge.
thought it was Eki first.
Yeah, JP Eki, then JP Madison.
Thank you, Judge. I'd like to make a motion, if the court agrees, that we have a special session December 1st, which is after Thanksgiving, and it is the Thursday before a Monday, which would be a personnel committee meeting, so that way we can talk about it. And everybody, if we could collaborate and come up with the best possible plan, but everybody have at least contribute to the plan. My colleague, Justice Duncan, just did that. I think it's a great idea. Let's go back and think about it, but be prepared for when we come to the meeting. This is what is good, and let's look at it and let's have a great conversation and realize the employees are who we're accountable to. So I'd like to make a motion that we have a special meeting on December 1st.
We got a motion to have a special committee meeting on
Thursday, December
1st.
1st.
And a second by J.P. Dennis. All in favor? Aye. Those opposed? No. All right, sounds like we have the ayes have it. No, Ms. Collins, you want to go ahead? Let's go ahead and do the roll. We got to finish the motion, make sure we get the motion taken care of. A special committee meeting, personnel? Oh, quorum court meeting. All right, so go ahead, special quorum court meeting, Ms. Meyer. Let's go ahead and do a roll call.
Eva Madison? Yes. Robert Dennis? Yes. Suki Hires? Yes. Evelyn, Willie Lemming? Yes. Jim Wilson? Yes. Butch Pond? Yes. Lance Johnson? No. Shannon Marty? Yes. Sean Simons? Bill Usry? Yes. Patrick Deakins? Yes. Lisa Ecke? Yes. Sam Duncan? Yes. Chandra Washington? Yes. Pass?
All right. We'll move on to item 9.
Just a date.
We need to put a time. We'll put the time at 6 o'clock. Yeah. Go ahead, Council. Will you read the item 9 by title only?
Item 9 is an ordinance establishing the Washington County annual budget for the fiscal and calendar year 2023. It's on its second reading.
J.P. Deakins. All right, so they'll just move on to a third and final reading next month. Item 10, Council, will you read that one by title only?
An ordinance denying a conditional use permit recommended for denial by the Planning and Zoning Board for the J&J Concrete, and this item is on its second reading as well.
J.P. Deakins. All right, that one just stay on. Move on to the December meeting. Item 11. This is a Farmington. We got some folks leaving. I'm tired. All right. Item 11. Item 11 is the Farmington Quarry Cup appeal. We'll go ahead and have our planning team get prepared and ready. The process will have, again, a presentation by our planning team. After that, we'll have 30 minutes to have the applicant come and share. After that, then we will have those who may be in opposition to the application to come forward. Then we'll have discussion by the quorum court, and then they'll decide which route they'll end up taking. So with that, Mr. Blake, good afternoon, good evening. The floor is yours. Go ahead and tee it up.
Hold on. Myra, can you do it?
There you go.
There we go. Good evening. The Farmington Quarry Expansion High-Intensity Conditional Use Permit is sought for an expansion of the existing Farmington Quarry to the north and west of its existing operation. The existing site is approximately 188 acres, and or 108 acres, and a proposed expansion of 188 acres. A 150-foot buffer is proposed around the expansion parameter. To date, county planning has heard objections from at least 60 neighbors, all in unanimous objection to the CUP. The general arguments are reduced property value, noise and dust, disruption of natural habitat, disruption of private gatherings, blasting affecting structural integrity of houses, traffic safety and concerns, and general environmental concerns. Hunt Rogers Group provided a dust abatement plan to minimize dust from trucks, from its operation, and leaving the facility. Basically, from what I understand best, is that materials are screened, they're run through water. They use about 100,000 gallons of water daily in their operations, and also in wetting down the access roads inside the facility. The entrance and exit will have a wheel wash system to pre-wash the customer trucks prior to leaving the quarry site. The planning department recommends the following conditions: that the applicant maintain the required permits from ADEQ, the applicant comply with subsequent large-scale development regulations, trucks will pass through a wheel wash system when leaving the site, and that trucks must be tarped upon leaving. Truck traffic will be directed south on Hamstring Road towards Highway 16. Trucks related to quarry business will not be allowed north towards Harmon. And the applicant will follow the submitted dust abatement plan. Changes that occurred from the previous meeting were the striking of number 7, maintaining an average blasting of once per week. That's apparently economically infeasible, and it was explained by representatives of the group that they reduced the charge size so that there's less disruption. And the hours of operation were changed to match the Hunt Rogers project in Springdale, that the applicant will not blast or operate his plants on Sundays, after 5 p.m. on Friday, or after noon on Saturday, or major holidays. The applicant will provide notifications through phone, email, or text message to interested parties at least 24 hours prior to a blast and 1 hour before the actual shot time. The applicant provides a third-party monitoring service to maintain seismograph equipment in affected areas in order to monitor each shot for air pressure and vibration compliance. And also to provide neighbors on request portable seismograph equipment at their homes for a time to track readings at their location. The applicant will repair potholes and other road damage on Hamstring Road leading to Weddington, Highway 16, on an ongoing basis. Items 13 and 14 were struck because they can't be enforced and they would seriously curtail the operation of this facility, and also to align with the Springdale Hunt Rogers operation. The applicant will maintain a neighborhood committee, which will meet at a frequency determined by that committee, and also the funding of an ombudsman, which will be an engineering firm with an office in Washington County, approved by both the applicant and the neighborhood committee. Participate in the neighborhood committee, field and investigate the neighbors' complaints, and reporting noncompliance to the county. Ingress and egress to the quarry is limited to the existing entry-exit point. No new entrances have been requested or reviewed. And the applicant shall maintain a 150-foot minimum buffer and provide screening in the form of natural vegetation and trees to minimize visibility and impact from adjacent properties in the expansion area. Here is a summary of the citizens that have commented in opposition. This CUP comes to you failing to be tabled and failing to approve at the previous planning board meeting held in September. So the CUP failed to be approved. I believe the applicant is here to field any further questions.
All right, let's have him come. Come on.
I have a question for
J.P. Dennis. That's not hitting it.
Oh,
Excuse me for my little analogies, but I've got a favorite stoplight in Farmington that doesn't do anything except for stop the traffic. And I run it, and I don't get a ticket. Myra, don't listen to any of this. And so I run it, and nobody turns me in. And so
in Farmington?
in Farmington, so I just keep on.
You're lucky.
I keep on running it, and I'm going to keep on running it because nobody does anything about it. So my question for you is, when someone breaks the rules, how do you, someone calls and turns me in, Myra turns me in tomorrow, I'm just going to say, no, I don't really do it. That was just a joke. Who really enforces? You've got a lot of rules, and if all those rules are followed, then it makes for a peaceful neighborhood. But if they're not, it doesn't. And I've heard these rules before, and I've experienced sitting on court for a red dirt pit before. I've had good friends that live next door to it. I've gone out and visited, and so clear it for me on who's going to enforce it if it's done wrong.
Typically, it's an escalation. Reach out to the company in question, Hunt Rogers Group, attempting to clarify the issue and resolve it there. If it doesn't seem to resolve, then we proceed to involving the county attorney, potentially to address the issue.
And then
Ideally, the big rules are enforced by ADEQ outside of the CUP conditions. And yeah, there is a matter of the good grace of the applicant to abide by the rules.
I know I shouldn't run the light, but it's just too easy to go ahead and run it. So you get my point, and I think Rogers Group probably gets my point too. But it's just too easy to go ahead and shoot that dynamite off because I really need that load of dirt tomorrow, and I don't see how we as a county can regulate that.
It's a fine line, and I don't really have a great answer for you. That said, there is an opportunity now to hash out these conditions. These conditions are largely verbatim from Springdale, and we have a chance to add, modify, change at this time. But as far as enforcement, it typically is a...
Do we have the authority as a county to enforce it?
I argue we do.
You argue that we do?
Thanks, Blake. J.P. Ecke and then J.P. Madison.
Thank you. Honest answers.
Thank you. Just a question. Has the CUP ever been revoked? Has a CUP ever been revoked because they violated the conditions?
Potentially, but not to my knowledge. But I've only been here for about a year.
J.P. Madison.
Thank you, Judge. I'm curious if all of the dirt pits operating in the western part of the county are subject to these conditions. Do you know?
I believe there's one in operation that is operated by a private businessman for his own projects. I don't know the details of that particular project off of, I believe, Harmon.
What about the Lindsay pit? The Lindsay pit?
I do not know.
It just strikes me as a little odd that we're gonna make them have a wheel wash when other people can move their trucks at will without a wheel wash. So it just seems like perhaps I don't know. It just seems odd to me that we have pits that have no restrictions and then we're coming
And I cannot comment on anything outside of this particular project right now without being educated on the matter.
Okay, thank you.
JP Simons, and then JP Lemming.
Thank you, Chair. Mr. Chapman, this particular applicant operates in other places in Washington County. They have conditional use permits currently in place. Do they have a history of being fair and compliant?
That's a subjective question. I do understand the compliance from neighbors that have called me about the Springdale quarry, that they have been in compliance. I've not really received any complaints of non-compliance.
This seems like a pretty
For the Springdale
extensive list of mitigation tactics that seem like they're doing their due diligence to be good neighbors. An expensive effort to conduct business that's needed by Washington County. We need aggregate, we need dirt.
JP Lemming?
I was going to help Eva a little bit. The different pits take different things to work with. When you talk about blasting and grinding that aggregate up, it comes out to a fine grit, and that fine grit gets tracked out on the road. Hunt Rogers has said whenever they done the quarry over here at Sonora that they was going to put a wash deal in for your trucks. I own dump trucks. I haul out of their pits. I've never had my tires and wheels washed at the quarry over here. There's always dust blowing everywhere. There's always water running down the hills. So you got to understand, in the red dirt pits, there is no blasting that happens at a red dirt pit. There is really no dust that happens at a red dirt pit except what the little bits on the road. And so there's two different materials you're taking out, and there's a lot of different rules for blasting and crushing rock versus taking red dirt out or taking slate out. It's totally different animals you deal with. So Hunt Rogers does have a big dust problem at their pit there, and they do need a wash pit there for their trucks. And saying they keep the maintenance up on our county road, you go down that county road, shoulders are that deep, potholes in it. They haven't never done nothing on that road. I go up and down that thing a lot. So Hunt Rogers is telling stories that's not true. They're not being good neighbors on my side of on the outside looking in, hauling out of there with my stuff. I know they're not being good neighbors, and they do need to be good neighbors, because when they blast, the question I asked the attorney over here at this other place, they blast and they blow a neighbor's window out, and I asked him, does Hunt Rogers pay for it? His exact words sitting at that chair says, you got insurance for that. Well, that's BS. We don't need to let them put them there if we're going to be a sour neighbor. If they blow a window out of a house or they bust their sheetrock, they need to fix it. It's no different than me running over somebody in my car. If I tear it up, I need to fix it, plain and simple. So Hunt Rogers needs to step up to the plate. Yeah, it's expensive. Mr. Simon, you said it was expensive. Anything you do in life's expensive. You're going to mine rock, you need to pay the price. You need to pay the neighbors. You need to keep up the roads. You need to control your dust. You caused the problem. You need to fix the problem. Thank you.
We're going to go ahead and bring the applicant up. Thanks, Blake.
Are you seeing me now? Okay. Members of the Quorum Court, thank you for your time. My name is Andrew Effinger. I'm actually the Assistant General Counsel of Rogers Group. I work out of the Nashville office, which is our corporate headquarters. I'm here to do a brief presentation. You guys have already gotten a little bit into this, so I'll breeze through some of it that you've already heard from the planning folks. I do have a representative of our third-party blasting firm, Vibratech, here with us, and several of our officials if we need to get deeper into the weeds on anything. So, to begin with, I just want to let you know who we are in case you don't remember. I know it's been a little bit of a time. Hunt Rogers is a joint venture between Hunt Ventures, which is run by Joan L. Hunt. J.B. Hunt started the Springdale Quarry. We threw in some of our quarries and put a JV together back in 2013. Just to address right out of the bat the elephant in the room, why we appealed. We did receive the majority of the voting members' support of passing this. And as was just mentioned, the motion to table failed. So we did have several members of the planning board who thought our proposal was just fine. As to the amendment to the proposals, one of the planning board members said, we'll let the quorum court figure that out. So here we are. I think he had a decent point that no matter what happened, this was going to be appealed to you guys. And at a high level, our view of this is, to J.P. Dennis's point, what is necessary in these situations is some accountability. And we hear stories, especially myself being from the corporate office, going out and meeting neighbors at quarries where I don't work every day. You'll hear a story about somebody called and said, this is what they said to me. Well, who did you talk to? And they don't remember the name. And we don't have a log of anybody doing anything with it. So the best framework, especially once we're partnering with the local community government, is to establish a third-party ombudsman, communicate to the community that they can reach out to that person if they see something going wrong, give that person access to you and the Planning Commission if there's a continued problem, and then we'll have regular meetings on demand based on neighborhood input if they need to have a meeting, and we will work through the effort to make reasonable efforts to fix any problem. You know, we can't, there's some problems with a quarry that, you know, a little bit of dust here and there is going to happen. We'll do what we can to mitigate what we can, and we'll work through the issues the best we can. And that's why we came with this appeal. We think with the package we've put together that several of the planning board members approved and the accountability that it builds, we feel like the quorum court can vote in our favor on this. Just to remind everybody, we already talked a little bit about this. We make crushed limestone. It's used here locally. This isn't something that's mined and shipped off internationally or throughout the United States. Concrete and asphalt uses this rock. It's needed for homes, schools, offices, churches, hospitals, everything, right? You're sitting in a building built with a whole bunch of crushed stone. We do sell some dirt and clay and topsoil. As to what's mentioned about the regulations earlier about DEQ, Arkansas DEQ does monitor the water and the air permits. The Department of Labor and the Fire Marshal monitors all blasting. We use a third party for that, but it's all regulated here in the state of Arkansas. The Mine Safety and Health Administration, MSHA, regulates everything that goes on any mine in the country for safety reasons. We do dust exposure studies with our people that are inside the plant getting really close, and we make sure that when people need masks, they wear masks, and so we expose people, or we test people based on the exposure to see when we do and do not need masks to make sure that everybody's staying safe. All right, are we better now? Okay, yeah. And there's also Washington County regulations. This site already operates under an LSD, and obviously to expand it, we need the CUP that we're here requesting. So let me just move on a little bit. We see here just a picture to explain. I think this was attached to the letter that I sent to all of you guys. We have an original site that we purchased in 2010 after we operated it for a few years in partnership with Lindsay, who just came up in the conversation. Later on, we purchased this big red dirt farm down to the south of us, which got approved by a third party. They went through a conditional use permit process. They got approval to run a second quarry on this road, and after they ran into some business difficulties, didn't decide to launch it. We acquired that property as future reserves for our single site. One of the conditions that was removed was the 200 truck load limit. Just for historical purposes, that 200 truck load limit was applied to the big red dirt farm when it was approved, and that was going to be additional truck traffic to our quarry. So we've got a conditional use permit on that second site with that 200 truck load limit on it. What happened in 2018 is up to the northwest here, this property went to auction, about 60 acres, you can see on this map that it has already been stripped for red dirt. The red dirt was taken and hauled out through our site pursuant to a lease years and years ago in the early 2000s, I believe. So we went to the auction, we won the auction, we got that piece of property. It actually is in the same geological formation, moving to the northwest, a ridge that we're mining. So we figured a way to continue chasing the rock that we're in, and it required that we made another purchase in 2020 and another purchase in 2021 to create the corridor along that ridge to move in that direction. It actually moves away from most of the neighbors. It moves up into the northwest. You know, the more populated part of town is to the southeast. It also has the benefit of having some natural barriers. To the northeast of that ridge, there's a big wooded area and there's a 100-foot drop-off. We will create the pit behind that high point so that, unlike Springdale, where we were going to have some issues with people's view from their back porch, the people to the northeast here will continue to see that ridge the same way it looks now. We'll be behind it, making a hole in the ground. And we had a meeting on Tuesday with some more neighbors and explained that to them. There were some people that had some questions about what was going to happen to their visibility from Hamstring Road up to the north. So as you can see here, this is the plan that was just presented. It's on these 3 new parcels. We're going to move up to the northeast. For those of you that have been following along really closely, that corner up to the northeast is going to be brought back into the high point of that ridge. This was an engineering drawing that was just based off the offsets from the property lines. So I apologize, this is going to be a little bit of a tweak, but with the conditions that we have in place, we're going to maintain that natural barrier on the high point of that hillside. As to the conditions that the planning board is delegated the authority to evaluate, we paid all the fees, so forth and so on. As far as public services go, we've agreed to fix all of the potholes on Hamstring Road on the way that our trucks are going to go, basically from our entrance to the next major roadway. As far as compatibility is concerned, we're preserving the natural buffers where we can, and it is adjacent to a mine, and it has already been a red dirt farm in the past. I think MSHA and DEQ compliance would alleviate any concerns about public health and safety. We're already being regulated in that regard. As far as the surrounding impacts go, you know, we've paid healthy prices for these properties we've acquired, which has assisted with probably the property values in the area. So we don't feel like this expansion is going to have any kind of effect on the property values. And then as far as orderly development goes, we talked about this with Springdale. Orderly development of the community as a whole requires facilities like this, and we're going to have facilities like this somewhere. This is where one is. We can develop the infrastructure around it as this thing grows. To be clear, as I mentioned in the letter, this expansion is more acreage. It does not increase the volume of material that is leaving. The volume of material leaving our plant is dictated by what construction work is going on, whether there's a big road project, whether there's a big building contract going on. This is just for the longevity of the quarry, so the quarry will just be there. And that allows for orderly development across the county rather than having another quarry need to be developed somewhere else. The planning folks went through these revised conditions pretty clearly before. I'm not sure I have much to add. As to the comment about blasting once a week, it would be really silly in those seasonal demand periods where we need to make more rock because somebody needs to build a highway for us to have to make bigger shots. What we would prefer to do in those situations would be to shoot twice that week with smaller shots. Right, there's no reason for us to have a lot bigger impact less frequently when we can just have smaller impacts and maybe a little bit more frequently. So that's why we asked for that one to be removed. The hours of operation, we think what we did at Springdale is sufficient, so we asked for that to be revised so that we have the matching just for no other reason than just for business continuity reasons to understand that we have the same restrictions in the same county at both of our quarries. Like I mentioned before, the truck count of 200, that was a condition on this other conditional use permit on the property that we purchased, but we do more than that now. So that one got in, and I'm not sure why. It didn't make much sense. And then as to the employees, you know, we need the employees we need to make the product we need to make seasonally from time to time. And, you know, the number of employees we have in a February is a lot different than the number of employees we have in an August. And if we need some more to do something safely, we need to be able to do it. And with that, questions, I'm willing to take any questions, and If you'd like, I can come back up after you hear the public comments. One of the challenges we had with the planning board was there were a whole bunch of comments, and we suggested if they had issues, we could apply some more conditions, if there's something that they'd like to address. So if there's anything like that that you guys would like to discuss with us, we're all ears. And with that,
Well,
I guess I can
we're
reserve
going to
first.
go ahead and let you, we still have a little time left. If there's others who are in support of this project, they can come up and talk. And then we'll go in and let those who are opposed to that go ahead, and then we'll go back to the court to have them have discussion. So you're good unless there's some others who want to come up and visit in support of the project.
Not everybody at once.
When we get to the court. Anybody in favor of this project, you can come forward. All right, with that, then let's go ahead and have a 30-minute time for those who are against the project to come and talk. 3 minutes apiece. Thank you, sir.
Thank you.
Tell us who you are and your name, where you live, and then go ahead and make your comments.
Good evening, everyone. My name is Jim Gallagher. I live on Martin Road in West Fayetteville, actually Washington County. And I am on the road directly across from the entrance of this quarry. His job was to come in here and put as much makeup on this pig as he could. My job is to remind you it's still a pig. And we have to live with this day in and day out. They can show you all these statistics about blasting and how they're under a certain threshold for each blast. But what I want to remind you is this goes on relentlessly. For those of you who were here 15 years ago when they had that earthquake in Oklahoma an early Saturday morning and you felt your house vibrate, that's my house every week. Not one blast is not going to damage the house. It's the constant vibration from the trucks, from the blasts that are doing damage to our property. If I gave you a piece of wood and an 8-penny nail and a hammer, and you put that nail on that hammer, on that board, and you hit it, you probably wouldn't hardly make a dent. That's what he's telling you. But if I gave you enough time and you hammered long enough, you would drive that nail all the way through the board and probably split the wood. That's what they're doing in my house. And they do it every week. They are supposed to have some sort of controls on them. If you don't, I don't know why any of you are here, but to tell you we can't regulate blasting, we can't regulate truck numbers, that's ridiculous. They didn't say 200 isn't enough. They just said you shouldn't have any, no restrictions. We should be allowed to do whatever we want to do. They told you that they have an LSD. I will tell you right now, you can walk through this building and search every record you want. They have never gotten a Washington County approval. They came here in 2009 and asked for one, and I sat right where you're sitting on the planning board, and we turned it down. It came in here to the Quorum court that was sitting at that time. They turned it down. They went to court after court after court. They got turned down. When they got to the Arkansas Supreme Court, they withdrew the application, and it was never approved. They don't have any approvals. They lied about grandfathering it in. They came in here and they told the current judge and the county attorney that they were operating that quarry before the zoning ordinance was passed.
All right, Mr. Gallagher, thank you.
Then the ordinance was passed, and then they applied for their permit.
Thank you. Thank you very much. Come on, tell us who you are and where you live.
My name is Kiki Kristen Bernards. I live at 329 Railway Road in Springdale. I am a patron of Apple Star Farms. I'm a patron of Apple Star Farms that is being directly affected by the blast. If you do a simple Google search with the terms Rogers Group quarry complaints, it lists hundreds of articles from newspapers all across the country for this $1.98 billion company. This company is not lacking in resources. And every article lists these people, communities across the country, just like ours, who complain to their elected officials, who complain to the fire department. They have no recourse. In the Hendersonville Standard newspaper in Alabama, I quote, "The community is left with very little recourse. Everyone feels pretty helpless about it." Every article is residents begging their leaders to put ordinances into place when they are told, "We'll look into it." What the Rogers has done is set a precedent. In their operations, they move into communities with little or no regulations, and they easily sway public officials. They blatantly violate codes and laws, circumventing procedures until they have worn down public and placed their own operatives in decision-making positions. In the last board meeting, a board member had to excuse herself due to a conflict of interest with owning stock in Rogers Group and voting on the expansion. We are grateful for her honesty to withdraw herself in the final deciding vote, yet we didn't realize that voting members would not have excused themselves from voting at onset when a conflict of interest was present. We do know that Planning Board Joel Kelsey is also the sales manager for Rogers Group, and though he could not vote at the board meeting, we are still not comfortable that this proposal came up during his politically appointed position, and we hope that that didn't have any influence at all on this proposal. This has raised the question for me, for all of us, is there anyone in this group that would have a conflict of interest in this vote? Have you received any gifts? Do you have any stock? Do you have anything that would sway your decision in this vote? We ask that you be honest about what you decide in these proceedings. Thank you.
Comments? Public comments?
She's going to try to set this up so you don't have to
Part of your 3 minutes.
suffer through.
Tell us who you are, where you live.
My name is Terry Davis Beaupre. I live at 16035 Beechnut Lane. Just in case she doesn't get this in time, I'll start. Here are some facts. This is a map you've seen many times and was first presented by Dr. Von Brahana, a distinguished professor in the geology department at the U of A, when this legislative body denied the Heritage Farms dirt mine. It shows how much of the Boone Formation is present at the surface in Washington and Benton counties. Keep it there. It's the predominant gray area covering, and it's the predominant gray area that you see covering 1,250 square miles. Notice the red dot. That's the approximate location of our community. This next map shows just how many mining operations exist in our neighborhood. A full 1/3 of this tiny 3.2 square mile area has mines and quarries. In many people's minds, taxation equals representation and everyone should pay their fair share. Taking into account only the last 2-year period, homes and farms in this neighborhood paid in excess of $1,114,000 in property taxes. Considering the ownership of the area, one would think the mining operators would then pay approximately $500,000 over the same time frame. They were taxed $19,000. These 6 mining operations that take up 1/3 of the land are paying less than 2% of the taxes. Those are taxes that go to support our local schools, taxes to repair the roads that are crumbling under the massive burden of the nonstop heavy haul truck traffic, taxes that support our local law enforcement. Some of these mining operations are even being allowed to conduct their business under an agricultural classification, which means they are paying less taxes than the properly permitted mines and are an even bigger cheat to the schools, roads, and law enforcement. We are already bearing the brunt of the burden to supply these resources to the area. To add insult to injury, this mining operation that has been a terrible neighbor is expecting you to grant an expansion to their quarry. I attended the September 29th Planning Board meeting, during which the board members courteously listened to an hour of varied and detailed grievances from residents with very little repetition. After such a long list of complaints, Neil Helm, one of the planning board members, said this to the Hunt Rogers representative.
It's a bit painful to me to know that 2 years ago we approved that, and we're hearing a lot of the same stuff today. And I don't understand why you wouldn't have precluded this from being the situation in another mine that wasn't involved in this in Springdale. I don't get it. And you know, it was on the credibility of Mrs. Hunt that finally was passed. Mm-hmm. And quite frankly, you're tarnishing Mrs. Hunt's word.
How much longer?
And that troubles me.
You don't know how much longer? Okay.
This appeal needs to be denied.
All right. Thank
I'm
you
done.
very much. Thank you. Public comments.
Good evening, ladies and gentlemen.
Tell
My
us who
name is
you are.
Kenneth Webb. I live at 15959 Hamstring Road in close proximity to this mine. I'm a veteran engineer and a craftsman. We went to the Hunt Rogers mine for their neighborhood meeting on Tuesday, heard their presentation, and listened to their justification of why the unregulated blasting is acceptable. There is, however, consistent disparagement between what they say and what they do. There are numerous studies performed by the USGS and other accredited sources regarding damage to foundations and structures caused by blasting operations. Hunt Rogers assures the neighbors that this isn't possible because they are within parameters of vibration frequencies and air overpressure decibels they deem acceptable according to the monitoring of the third-party company Vibratech. There are other news articles online of the same exact situation across the country where mines claim they are conducting blasts at safe levels and residents are enraged that their light bulbs are exploding after a blast. The reality is several neighbors have already suffered damage to their homes and foundations. Numerous wells have gone dry in the neighborhood. Historic homes are having to be evacuated and windows have been broken. In their meeting on Tuesday, we brought up numerous counts of neighbors in multiple states complaining of structure damage related to Hunt Rogers mines operating in their neighborhood. Hunt Rogers Group assures us this won't happen. The question is, what exactly would happen if a crack appears in our foundations as a result of living in close proximity to this mine? I called insurance investigator Ted Scallion at the Arkansas Insurance Department to get clarity on this question. His answer was, after reviewing several homeowners' policies issued by insurance companies licensed in Arkansas, we have found that damages to dwellings caused by blasting at quarries would be excluded under most circumstances. The reality is, no insurance carrier will pay for a claim for this exact situation, requiring an additional earthquake policy which costs the homeowner at least $400 per year and carries a very high deductible of 10% of the entire property value with still no guarantees of coverage, as it is not an earthquake. There are whole law firms devoted to helping residents fight legal battles to fix their homes after damage from quarry blasts. Either way, property owners are left holding the bag while these non-local companies make another buck. The citizens of this area do not consent to continuing to turn a blind eye to an operation that was never legitimately permitted by the county and does not consider the impact to our neighborhood. Vote no on this appeal.
Thank you very much. Public comments?
Good evening. My name is Roma Gray. I live at 15946 Harp Road. My house is across Hamstring Creek from the quarry on the north side. This is an area where they have already been moving closer to us. The gentleman said earlier that the natural buffer would not be disturbed or destroyed to the north of the current quarry. They already have breached that. I can see the top of the mountain already gone. Rogers Group has operated with impunity since taking over Stevens Red Dirt Farm in 2007 when they were grandfathered in. They have a pattern of deception and disregard for the rules and for the neighbors. This is not a neighborhood Dairy Queen. It is a high-intensity industrial operation. The CUP application through the Washington County Planning is an imperative part of ensuring the appropriateness of these CUPs. If you will permit me to show you a few things that they have, sorry, I'm nervous, even shown disregard for the planning application. Their hours of operation, I see, have now been changed from what was in their original application. I can tell you that they have rock crushing and trucks going way beyond 6 p.m. in the summers. They're not following hours of operation. The question, will there be outdoor lighting? They answered no. In the last 6 weeks, when I walk out of my house, which is at a higher elevation than a lot of residences, I was blasted with bright LED lights shining to the north, not in part of the pit. I have a crummy camera. I did the best I could to take a photograph of that a few nights ago. I can't see it. Okay, question, will you construct in phases? If so, please detail the construction planning schedule. Their answer was, we will proceed to the northwest when the time comes. That is not a planning schedule. That is not a detailed answer to this planning application question. The question, oh, I'm sorry, guys, it's my eyesight. The existing quarry has been in existence for 20 years. That is a false statement on their application. They only began taking over that 2006 or 2007, not 20 years ago.
All right, go ahead and start wrapping up.
All right. They rubber stamp multiple times that they're not going to influence the public with this expansion because it's already been an existing quarry. The existing quarry was originally a 45-acre piece of property. Now the expansion, 107 acres, is moving closer to a lot of us. They would like for you to think that there aren't many of us and we don't matter.
Thank you very much. Public comments.
Good evening, Judge. Hello. I live in Lowell. My name is Lisa Mann. I'm a registered nurse with a master's degree in nursing, a bachelor's in nursing, and I'm currently employed as a medical instructor teaching at a local private college in Springdale. I have been working in the medical field as an RN for 18 years, whereas the past 12 years have been specifically in Fayetteville working with over 2,000 veterans who've been diagnosed with respiratory conditions including COPD, coal workers' pneumoconiosis, which is commonly referred to as black lung, from the short and long-term exposures to harmful and dangerous toxins and chemicals that they've been exposed to. As a medical advocate for patient safety, quality assurance, and public safety, I know from experience that particle exposure can lead to deadly and catastrophic health effects. The exposure risks are numerous studies obviously in the literature I've provided, link exposure to particle levels to increase hospital admissions and emergency room visits. These conditions include incurable lung disease, massive fibrosis, lung and other cancers, COPD, and kidney disease. Fine particles from mining operations, which is a PM10 or smaller, such as those resulting from operations are found in slag dumps arising from the erosion of contaminated soil, disperse readily into the environment, often in association with aerosols, and may travel quite a bit further than ever anticipated, and that's from 3 studies. Fine particles also penetrate more deeply through the respiratory system, so if there's fine particles, it's going to cause a bigger problem with lungs and are more likely to result in adverse health effects of all the neighbors involved. Mining operations are understood to have some of the highest concentrations of potential harmful contaminants derived through anthropogenic activities, along with the highest particulate emissions and the highest risk to both human and environmental health. We talk about chat. This is lead, a zinc compound, which is a local term for mining waste made of this compound, and it can also be a hazard to human health. The chat particles, we're not as worried about the dust as we are about the soil, which is used to grow the food at the farm of these people, the surface water, which is present on the farm properties, and then to the groundwater, which is also present on the property, and then, of course, obviously the air from fine and coarse particulate matter, as I mentioned. Exposure to this chat, which contains lead, has also been known to cause learning disabilities and wreak havoc on the immune system, blood, and nervous system. Children are the most susceptible to these effects from chat. We have children on the farm. My son goes and picks berries that grow in this soil that is not yet polluted with this expansion. Furthermore, high levels of exposure may cause coughing, sneezing, and sore eyes. The dust deposits, residents, neighbors, and community members will all experience dust depositing on their homes, their roof, transportation of dust from roof to water tanks. They will not be able to avoid this situation and the mine dust exposures occurring in their backyard with this current plan that needs solutions such as geographical relocation. And even if the mine should be allowed to relocate, as all mines should be operated with proper dust controls, which according to the track record of this particular company that I thoroughly researched, may not be likely. The prognosis is grim, as we say in the medical field, to say the least. This mine would prevent the farm and the entire community from safe outdoor activities of any kind, and most likely cause medical complications that I will see in the hospital, and also our most vulnerable populations, children and the elderly that live in this community, which is not acceptable by any means from a public health perspective. Thank you so much, sir.
Thank you.
Thank you.
Public comments.
Hi, my name is Leslie Walker. I live at 19 Bresse Lane in Bella Vista. I take my son down to the farm to do hands-on things with the animals and to harvest and pick, and so it's a vital part of my community. And I've come today to talk a little bit about water. So I have some questions just to pose for us to think about moving forward and about managing what we know. One, do we have any data on how these rock quarries impact the streams and the watershed in this specific location? Two, is the water currently being tested and monitored upstream compared to downstream? I think that this is a basic step one to figuring out what's going on with the water and how it is potentially impacted. And then I want to talk about this area. In my research, I found out that this is called a karst area. And a karst area is made of limestone, gypsum, dolomite, marl, and carbonate, a topography characterized by sinkholes, caves, and underground drainage reasons. I can see why we want to mine in these areas, and I can see that the things are useful, but also I think that it's should be taken very seriously to mess with these structures because they actually shift a lot of the earth around. And I heard a story from a girl today who lives on Hamstring Road whose well was recently run dry from an explosion. They went to get water, there was no water. They're having to bucket water in from another well that still has some water. And who takes accountability for this? Is there a way that somebody could go to the company and say, hey, this has happened, and that they could care and respond in a way that is helpful to their neighbor, that takes responsibility for their actions. Limestone filters rainwater. Mining negatively impacts karst areas because the lack of limestone affects the level of nitrates, the pH, and the alkalinity of the water. Not to mention, do we know where this water runs off into and what is possibly being bursted out, creating new particles and being released into the watershed. Thank you.
Public comments.
I would like to request a little more time because I'm representing a group.
There's 5 minutes left, 5.5 minutes left in the total time, and you got a number of people behind you. So are you speaking for the people behind you?
No.
Okay.
My name is Jennifer. I live behind the quarry. I represent the voice of my community who considers our property a sanctuary, a resource for locally produced organic food, and a place of healing. My voice also represents the voice of my neighbors who can't be here tonight but have shared with me their concern. Some of them have been fighting this for 13 years and complain that Hunt Rogers Group has not been playing clean and certainly not by the rules. We know and understand that quarries are necessary to serve the ever-expanding Northwest Arkansas population. I have taken the time to not only talk with my neighbors, but also employees at the Hunt Rogers Group to try and understand the situation better. The plant manager informed me of the existing mine site, that they have plenty of material there to serve for another 30 years. In fact, he told me they don't even intend to use the proposed site for another 15 years. What then is the rush to approve this expansion? Where we landed at the end of the last boarding meeting is that there are many questions unanswered, many promises from Hunt Rogers unfulfilled, and a lack of trust from the neighborhood that things will suddenly change if they got approved to expand another 107 acres in our neighborhood. They simply don't have the track record, not with us and not with the many upset communities around the country who have suffered the same exact issues with Hunt Rogers in their backyard. They continue to break rules with not so much as a slap on the wrist, and that is just not right. We need to set a precedent that we can't allow that to happen here. We love our neighborhood and we are willing to protect it. There is no reason, there is a reason that no one is going to their neighborhood meetings. I went to their neighborhood meeting. It was not what we want in a neighborhood meeting. In Article 10, criteria for allowance of conditional uses permit, it states that the establishment, maintenance, or operation of the conditional use will not be detrimental or endanger the public health, safety, morals, comfort, or general welfare. An alarming amount of neighbors have reported such violations. I have some ideas about what we could discuss with the Hunt Rogers Group.
17 seconds.
How many seconds?
17.
I thought I had 5 minutes.
No, there's 5 minutes left total. The court can extend that time, but you got a number of people behind you.
Okay. As elected justice of the peace, you exercise the power to preserve the peace and order and secure freedom from dangerous or noxious activities. We need your vote today to help us vote no to this appeal and give us time to clean up the situation, bring integrity to it, and help us have faith that not everything is just about money. We pray to bring light to the situation for the benefit of all involved.
Thank you. Public comments.
Dick Johnson, 13650 Pin Oak Road. I've been here many times.
Mr. Johnson, go ahead and sit down and speak into the microphone.
Take advantage of the time.
There you go. I got you.
I'll cut to the chase. A lot of this information, both in your discussion and our discussion, has been way over my head. What brought me here tonight is I'm losing neighbors. 3 of my longtime neighbors, and I've lived out there 50 years, are moving away because we come up here, we have to come up here all the time to keep uncontrolled expansion of mining and red dirt activity from engulfing us. And they've given up, that they're selling out, and they're moving away. And that's from somebody that's not lying at all, and I can tell you who they are. To pour gasoline on our fire is the year that we spent sitting in here every week trying to defeat the Red Dirt Farm on Harmon Road. Your attorney, in one paragraph, granted them permission to run a red dirt operation, and they're going out every day and delivering right here on South College. I want to know who's running this show. Guys, I really do, because I do not want to lose any neighbors. I love this place. It's the best place in the country to be. That's all I've got to say.
Public comments?
Sherry Main, 15451 Riches Road, Fayetteville. I had hoped to win the election and be where y'all are sitting in January, but that didn't pan out. So I'm here to speak on behalf of living on Riches Road for the last 50 years of my life. I know y'all get it. You get what everyone is saying. I'm not going to repeat what everyone else has said. I lived 1,070 feet from the Hunt Rogers Quarry. It was behind my house in my backyard. They bought the property to the north of me, the 60 acres there. They bought the property over next to my property on the 7 acres. They had a way to go around me. They had a way to expand. They didn't need my property to expand. I was in the middle of a rock quarry and a red dirt pit on the other side, which is Whittington Mine acting as an agricultural business per a letter from the county attorney.
Ms. Mann, give me a second here. The opposition time is done. We have, is it just 2 more behind you? Is that just 2 standing? I can't see. There's a court. Okay. So there's a motion and a second. 3 minutes for each, for the 2 standing, a minute and a half to finish with Maine? Okay. We got a motion and a second to extend the time. 3 minutes for the 2 standing, a minute and a half for the 1 who's sitting. All in favor? Aye. Are those opposed? Okay. Go ahead, Ms. Maine.
Thank you. This quarry, I won't say they started by the rules. I won't say they didn't start by the rules. I don't know what the rules were. I know what the rules read in the county zoning ordinances because I was there. I was with the Para Task Force when they were started. We didn't have countywide zoning. And I had a dirt pit going in at the end of my road and no help. We were the Wild West. Jerry Hunton told me, I wished I could help you, but I can't. So I learned a good lesson there. And so I mentioned to him, why don't we have county zoning? He said, well, it's just a big project. I said, well, let's get on it. So then 4 years later, we got countywide zoning. Thank goodness. But why isn't the rules and regulations applied to everyone equally? Why is it some businesses can go try to follow the rules, try to do the right thing, come and get conditional use permits, try to jump through all the correct hoops, and other businesses can just run red dirt pits as agricultural businesses? And they know they're going to haul the dirt out for 5 or 10 years, maybe put 2 cows in there and a lean-to and call it a pasture, and it's okay. Or they can be grandfathered in. They may have started on a 20-acre plot. Lindy Lindsay, for example, that was a county quarry. And then Lindy Lindsay was renting it. 2188 LLC was renting that to the county. It was not him beginning, and it was on 20 acres. Now all of a sudden it's expanded to 160 as grandfathered in. Who decides all of this? It's not in the rules. It's not in the county ordinances. They are gray, I will have to admit, and they need to be tightened up. I've tried to be assistance to some degree trying to make that happen because I am familiar with the ordinances. I was there in the Para Task Force. Protect agricultural residential areas.
Thank you, Ms.
I get
Main.
looked aside, and I don't know if it's because they don't want the rules to be black and white and they want more gray
Ms.
in
Main,
it.
your time is expired.
But I'm
Come
I'm
on up,
just-
you two.
I'm just saying, I know y'all are in a hard spot.
Thank you.
Everybody
young
else
fella.
talked a little bit over their time, okay?
I did extend some extra time to you, Mrs. Main. Come on, young fella. Come on, take your seat.
Sorry, I don't mean to use your time.
Good evening, and thanks for extending the time. My name is Paul Turney. I live at 15940 Hamstring Road, which is about a half a mile from the site of the Farmington Quarry. From the front porch of my 1940s built farmhouse, I can view the area of the proposed expansion. I, like many of my neighbors, as you've heard, am concerned about the continued blasting at the quarry and the harm it may bring to the structural integrity of our homes. While a single blast may or may not produce damage, consistent, regular blasting poses a real threat. Also concerning is the potential threat to the well on my property from which I get all of my water. I moved to this region because of its natural beauty. I also chose to live outside of town to enjoy the quiet and scenery that area offers, but between the blast, excavation, and regular hauling truck traffic, that country lifestyle is being compromised. Further, in spite of the comments shared by the quarry attorney, I think it likely that the view from my porch, and which currently serves as a buffer between my home and the quarry, will not survive further excavation. I do understand that the Northwest Arkansas area is growing at a very rapid rate. I do accept the necessity of acquiring raw building materials so we have a sound infrastructure and places for people to live. However, as this quarry sits in the backyards of a large number of citizens, this growth should not come at the expense of these families. The quality of their lives should not be compromised in the name of profits to the owners of the quarry. For these reasons, I ask the court to reject the proposal for quarry expansion and consider stricter regulations for this type of land use near neighborhoods like ours going forward. Thank you for your time and consideration.
Come on.
My name is Michael Luna. I live at 15946 Harp Road. I'm kind of elevated, so I'm looking right across at the northeast corner of the quarry. And like my wife said, they have recently put up high-intensity lights, and I think there's some buildings up there. And it says on their permit that there aren't going to be any outside lights, and it also says in the permit that if there's any misrepresentations in the permit, then the permit is invalid. So that right there will make the permit invalid because they've got these lights that they put up that I don't know if anybody else can see them but us, or anybody that are at our elevation, but we can see them, and they're definitely up there, which is in violation of what they said they were going to do right off the bat. And I'd like to point out, on our way up here this evening, we drove up Hamstring Creek Road, the paved part, and there were at least two areas where gravel had spilled out of overfilled trucks that probably didn't have tarps on them and are creating a safety hazard there on that pavement. One of them was on a curve. So that happened. Now, the truck driver's not going to stop, but at least two of their employees leave that quarry every day and drive up that road. So they drove right past that and didn't care anything about removing it, sliding it off in the ditch with a broom or whatever. And I think that pretty much epitomizes how they really care about the community and the neighborhood. They don't. And and if you live out there, it's very, very obvious. So, but everybody else has touched on the blasting. If you stand on the third floor of my house when they blast, it'll nearly knock you down. So to say that there's no damage being done, that's a hard stretch. And also, the man volunteered that they're blasting twice a week. Well, sometimes they blast twice a day, and that's happened several times in the last couple of weeks. I'm home all day. I've been working from home. So I feel it every time they blast, and so they'll blast once and then wait 30 minutes and blast again. And they're not copying to that. They just said they blasted twice a week, not twice a day. Thank you for your time, and I really appreciate y'all letting me get up here and say this over past the limit. Thank you.
Thank you. Before we go to the Quorum Court for your guys' discussion, are there any agencies here, Arkansas Department of Environmental Quality or Department of Health? No? Okay. Court, it's yours. JP Madison.
Thank you, Judge. I just wanted to say to the citizens who've come to us tonight, thank you so much for coming. I feel that over the past several years, your part of the county has really had a rough go, and I think we've kind of let you down with dirt pits. I think back to, this will be my last dirt pit that I consider as I'm going off the court, but I look back at the dirt pits that we've considered out your way, and it's not a good track record, and I'm sorry for that. We had the the MMSW mine that they started mining before they'd applied for a CUP. It was then denied. We had the Weddington mine that we denied, that then they started running, claiming it was personal use. Now they're running, saying it's agricultural use. We have the Lindsay mine that somehow miraculously was grandfathered in because it had been a county mine, and they got an expansion without anything that Hunt Rogers is having to go through now with no conditions. And so I feel your frustration, and I'm very sorry. We've got to do a whole lot better for how we regulate this process, and how then once we grant these conditional use permits that we make sure that people are living up to their conditions and that you all can enjoy where you live and not have to move. So I just wanted to say that because I feel like over these dirt pits that we've considered, we've really let you guys down. We're not doing a good job.
Any other discussion on the court? JP Deacon.
Thank you, Judge Wood. Well, I feel kind of obligated to speak. I think it was early last year that we had the same organization with the Springdale expansion in my district, and I understand. I want to say that's probably one of the most gut-wrenching issues I've ever had to deal with on the Quorum Court, to try to bridge neighbors and industry together. But I would like to say that this is a critical need for our area. We have to get these materials. They have to be closely located. And after working with the company and putting these conditions on there, I can say that their reputation in my neighborhood has grown immensely. And my feeling is that they are meeting their commitments that they made to my neighborhood and my district. And so when we think about that and we think about the critical need for these materials, these kinds of operations are never going to be perfect. I think everybody understands that in terms of how they have to operate and the industry they operate in. But if we have an operator in our area who is embedded in the community, and we know one of these, Ms. Hunt, is very embedded in this community. She cares a lot about, I think both her personal reputation and also the reputation of her operations. And they are here. They are self-imposing additional conditions to match the Springdale operation. And they're coming to us, and they're being players with us in terms of trying to make this the best we can. I ask, what more can we ask for out of an operator? And I go back to there are a lot of this that will be trust. The enforcement is a difficult issue. But once again, it was a very grueling process, and I feel that Hunt Rogers has come through and is fulfilling their commitments they made to my district. And so I leave that with the court, that I have to speak on behalf of what I've seen out there. Thank you so much.
JP Pine.
Yes, thank you. Thank you, Judge. I have a question for Attorney Brian Lester. What I always look for in these is there an actual legal reason that I could vote to deny, that would pass muster at the circuit court, which this will go to next?
There are several legal reasons that you can vote to deny. You can vote that it's not compatible. You can vote that it's
I think, I don't have the ordinance right in front of me. There's a list of 7 factors that the quorum court considers. Are you asking about what those 7 factors are?
Pretty much.
I'll have to, I'll come back to it if you want to go, and I'll find it.
JP Eki.
Thank you, Judge. I voted in favor of the Hunt Rogers Quarry in Sonora or Springdale because they did prove their case that they wanted to be good neighbors, and what would it take to bridge that gap? Hold on. I hear what the citizens are saying, and I understand, but what I would like is they have these conditional terms that they've come up with, and these are some of the best I've ever seen as far as a CUP. For a company to be accountable and responsible. Well, this is me. I'm just speaking from that thing. But my question is, what would it take? What do the citizens, Judge, want the Hunt Rogers team or group to do over and above what they're already doing? That would.
Well, hey, let me.
No, I'm addressing the judge.
JP Eki, stop. I asked you guys, so you guys had 30 minutes to support the CUP or to deny it or to speak against it. You guys have all had your time to speak on both sides of that. Now it's time for the court to do that. I asked you to, they respected you and allowed you guys to speak, and I gave each one of you guys a little bit more time. I asked the court to give you additional time. Now the court is having this discussion to decide should they support it or should they deny it. Allow them to have that discussion without your interjection. Thank you. JP Eki.
Judge, I appreciate that very much. And I do want the citizens to understand it is gut-wrenching, and we do hear them loud and clear. But my thought process is, in any situation like this is, how do we build a bridge? How do we build a bridge and how do we come together? That's just the way I am. And those that have served with me on this court know that that's exactly the way my mindset thinks. I want what's best for the citizens, and I want what's best for economic growth and development, and we need economic growth and development in this county. So that's why I was just asking the question, what can we do to bridge that gap? Thank you, sir.
You found those? Go ahead.
So the 7 factors the board has to consider, or that must be considered for conditional uses, that a written application has been filed with the planning office and the appropriate fee has been paid. And I guess in your case, JP Pond, if you find that any of these don't apply, would be a legal reason to deny. That the applicant has provided proof that each property owner, as set out in section 11-204, has been notified properly of the proposed use. That adequate utilities, road, drainage, and other public services are available and adequate or will be made available and adequate if the use is granted. That the proposed use is compatible with the surrounding area. That the establishment, maintenance, or operation of the conditional use will not be detrimental to or endanger the public health, safety, morals, comfort, or general welfare. That the conditional use will not be injurious to the use and enjoyment of other property in the surrounding area for the purposes already permitted, nor substantially diminish and impair property values within the surrounding area. That the establishment of the conditional use will not impede the normal and orderly development and improvement of the surrounding area for uses permitted in the zone.
Go ahead, J.P. Pond.
This I suppose would be my opportunity to, I already know we can't just say no, just because the people in that area just don't want it. That's going to get thrown out of court. But and I also know that there are certain things that come with quarries that are going to be there. And I'm not telling you I'd like a lot of that stuff either. I wouldn't mind some of that lime dust floating over on my hay fields. But the thing that I would ask if this condition is not already on there, that, because I heard 2 or 3 people, 4 maybe, comment that the lighting on that facility was a nuisance. I want to know if this condition's not on there, that, and this terminology for what that is, they've got shades they can put on those lights where the light is directed toward the ground instead of just broadcasting all over the neighborhood like some kind of beacon. If that's not on there, my ask, the condition I ask for is that those lights are shaded where they direct to the ground. I could not see anything else in their complaints that don't come along with a quarry that you're going to have some of. And this is what we're talking about, is a conditional use permit. And just to totally deny simply because a quarry is an unpopular thing to have, and we don't want one next door to us, will not hold up in circuit court, as best I could tell. We've not been successful with anything like that. I don't think it's an unreasonable thing to ask for reasonable conditions to make it more not such a big nuisance in the neighborhood. Thank you.
And JP Hires, and then JP Lemming.
Thank you, Judge Wood. I want to tell everybody out there that this is so hard for me to listen to. Whenever my husband and I, last several years, we've frequently talked about selling our house in the city someday and moving out into the country and having a little bit more space and a little bit more fresh air. And until I was a member of this governing body, I thought that was a great idea. And now I'm terrified to buy property in Washington County because I don't have any guarantees that my property will be what it is that, that we were looking for when we moved to a place like that. One of the issues that I've talked to a couple of the neighborhood folks, and it's my understanding, their understanding, that this group is already working outside of the grandfathered area, so they're already working outside of the area that they are permitted for, if the permit was even actually valid. And so I think that that's a concern to have on our radar. If they're already working outside their area, we keep talking about them being good neighbors, and that was something that has been said to me more than once today, that I'm a little concerned about if we were to move forward, if they're already kind of breaking that that code. That's all. Thank you.
JP Lemming, and then JP Simons.
We keep talking, thank you, Judge. We keep talking about lighting and stuff. The state of Arkansas, if you'll notice, when you drive down the bypass at night, we haul barriers and we work for the state, and we're out there on the interstates all hours of the night, and they do work at night nowadays to try to please the people during the day so they don't have to fight all the construction going on, and it's easier to work at night. So I'm not really taking up to the Rogers Group, McClinton Acre, all of them runs trucks all hours of the nights now because of the traffic so heavy up here in northwest Arkansas. They have no choice but to work at night. And lighting can be, they do a lot of things for lighting to where it don't blind drivers going up and down the interstates, and they can do work with lighting in them minds to control that better. And it sounds like Rogers Group needs to get together and make that happen. But the way this area is growing, you have no choice but to let construction companies work at night, because it's the law on the Interstate 49. We haul barriers for them, and if we're not off the road at 5 o'clock in the morning because all the traffic comes along, it's a $20,000 an hour fine for the construction companies. And so they're trying to work their best at night to do most of their construction, and so the construction crews can get off the road and open the other lanes and get all the traffic back going. So to put a stipulation on to where they can't have lighting at night and quit at 6 o'clock, you can't have the growth in northwest Arkansas. You can't have interstates being worked on all hours of the night. And you can't there's no way you can put a stipulation on any mining company to say, you got to quit at 6 o'clock, you got to start at daylight, you've got to let them work in the summer times at night so they can get the construction done, and that way they can get traffic running up and down the road a lot smoother. So I think that Hunt Rogers and the community out there needs to go back to the board, and they need to sit down, and they need to talk more about it and come up with some solutions. Maybe they don't do 107 acres. Maybe we just do 20 acres. Maybe they need to start blasting on just Saturdays, not every day of the week. And I understand they need to blast, but I've been out of Hunt Rogers Group. I've watched them blast a 5-acre tract one time, blow it plumb up out of the ground. 5 acres is a lot of rock to crush. And they ought to be able to crush on certain days and make it happen. And I think they need to work together to make up a good solution for everybody, or this is just going to go to courts higher than us, and it's going to get passed along, and it's going to make this quorum court look bad because it went to a higher court and they just overruled us. I think they need to work together and try to come up with a solution. We have to have the aggregate in the ground, and you can't just say, okay, you go to Prairie Grove on the south side and dig up rock. Well, that kind of rock ain't there. You got to go where the limestone is to get that rock out of the ground, just like red dirt. I'd like to have a red dirt pit out in the country where nobody is. But the fact is that red dirt ain't everywhere. You get out in my neck of the woods, you got big old boulder, big rocks, and that's all they are, and they ain't worth a hoot for nothing. So therefore, you got to go to where mines is. And yeah, they're aggravating, and yeah, they're a pain in the rump. But I think everybody can work together and come up with a good solution. Thank you.
J.P. Simons.
Thank you, Chair. I know we're sitting here kind of beating this horse, but it's worth having this conversation, and it is. My colleagues have said this is a hard decision, and we've faced this several times over the past couple years, and it's tough. Nobody wants a quarry in their backyard, whether you bought your house when it was there or if it moved into town. But I think it's important to keep perspective. This quarry is there. It's been there. It's there now. It will continue to be there. We're talking about expanding their footprint on the surface, and if we deny tonight, it will likely go to litigation. If there's not legal recourse to deny it, we'll get overturned. And even if it is denied, they're going to keep mining deeper, underground. We're talking about shaking houses and breaking windows and cracks in foundations. What happens when they continue going further underground, bedrock? Now, they're blasting at 1/3 to 1/2 of the state-approved limits. Appreciate that, guys. Like, I would rather you do it on the surface and not underground. So, this is tough. I get it. Thank you for the community members that came here. Thank you for planning, for going through their checks and their expertise on whether or not to approve this. I hate that it gets to us. I wish our planning could have made this decision for us. Thank you for Hunt Rogers giving these conditions and agreeing to be good neighbors. I agree. We need to have some teeth. We need to have some authoritative, other than levying a fine if they don't do this. The ombudsman is the biggest regulatory thing that gives this teeth. So we have to hold them accountable. We have to hold anybody accountable. We sling CUPs like they're going out of style, but we have no legislative teeth behind them. Our planning needs some sort of authoritative action when those CUPs are violated, and that compliance isn't there.
All right, so what is the pleasure of the court? J.P. Duncan.
I want to say I agree with several of my colleagues' comments around the conditions placed on the conditional use permit. I have obviously seen a few of these come through as well, and it is conflicting. The conditions placed, I feel, are appropriate. If the planning board member didn't have a conflict of interest, this would have passed through planning. And it would be a different story here tonight anyways. Separate from that, this is an expansion of an existing operation with what seems to be fair conditions. So with all of those comments, I move that we pass the CUP for approval.
All right, so we have a motion and a second. And it's on its first read. Motion is second. Any other discussion? Any other discussion? Oh, yeah, Council, go ahead and read that one by title only.
An ordinance ratifying a conditional use permit. Well, I don't have that. Do you have that on you? I've got the wrong one down here. Yeah. It'll be an ordinance ratifying a conditional use permit for the Farmington Quarry CUP.
So we have a motion and a second. Discussion? J.P. Pine?
There it is. Would, if it's not already on there, would, my condition I requested for proper shading of the lamps be in your motion?
J.B. Duncan.
Judge, I would happily accept a friendly amendment to add shading as a conditional use of the permit.
Would you, I'm sorry, there's discussion going on. I can only keep up with so much. What were you saying?
I think someone back there was motioning from the planning board that it is on there, but it isn't the CP. Am I wrong?
Okay.
Sam, out of planning department, there should be a condition like for lighting, and we do have a diagram, accepted diagrams. They're supposed to be like shaded, like pointing down, sheltered, so like they don't like point out. And if they, I will provide them with a diagram, like in the accepted kind of lightings like we use. Most companies right now, they're using LED lights that is like not like white, but like yellowish, so like they don't like reflect more. And they have like timers on them, so they can turn on and off in a certain time, and they can have motion sensor on them if they have any operation. But let's hope like they stick to the hours of operation that came with the CUP as well. Thank you.
Okay, so we don't have to have that. All right, and this is on its first read. We still go into public comments? Okay, so that moves on. J.B. Johnson?
I move we suspend the rules, move this to the second reading.
There's been a motion to suspend the rules, move to a second reading, a second by J.P. Simons. All in favor? Aye. Those opposed? No. Ms. Myra?
Eva Madison. Abstain. Robert Dennis. Yes. Suki Hires. Willie Lemming. No. Jim Wilson. Yes. Butch Pond.
Yes.
Lance Johnson.
Yes.
Shannon Marty. Yes. Sean Simons. Yes. Bill Usry. Yes. Patrick Deakins.
Yes.
Lisa Ecke. Yes. Sam Duncan.
Yes.
Chandra Washington.
No.
It would pass.
All right, Council, will you go ahead and read that one by title only?
An ordinance ratifying a conditional use permit for the Farmington Quarry.
Ratifying it? I just want to make sure we read the title right, because they didn't.
You're exactly right, we're approving.
Yeah, it's up there, so that's why I knew.
Okay, yes, an ordinance approving a conditional use permit for the Farmington Quarry expansion. Thank you, sorry.
It's on the second read. J.P. Johnson.
We suspend the rules, move this to the third and final reading.
There's a motion and a second to suspend the rules, move to a third and final read. All in favor? Aye. Those opposed? No. The ayes have it. Council, read that one by a third and final time.
An ordinance approving a conditional use permit for the Farmington Quarry expansion.
All right. Discussion. Oh, but go ahead and make who's going to make the motion to pass? J.P. Duncan.
I move to pass item number 13.1.
There's a motion and a second to pass item 13.1. Any discussion? Public comments. Public comments. It's public comments. One moment. Go ahead and take your seat, J.P. Ussery.
I just want to respond to some.
One second, J.P. Ussery.
I'd just like to say that we're going to be voting on this, but I really think strongly y'all need to sit down and talk. And I know that what I heard tonight was that
J.P. Ussery, can you talk in your mic?
I'm sorry. What I've heard tonight is that there have been meetings, but a lot of people have not showed up for those meetings. And it's going to take both of you talking to each other to get this thing worked out. That's really important to get this worked out for everybody. So I really encourage you to sit down and discuss this and just be open. Thank you.
Go ahead.
That's exactly what I wanted to share.
Say your name.
Oh, sorry, Jennifer, and I live on Hamstring Road. That's exactly what I wanted to share if I had time, because I feel like there's a lot of room for the community to come together and speak with Hunt Rogers. And my argument is that we ask that you do not approve this because we need more time. They don't have a track record that they've done the truthful thing, that they've honored the conditions, and we need more time to build trust and have conversations and make sure that we can find agreements before they can reapply, and we can do this the right way in harmony with the neighbors. It doesn't cost us. All the complaints that we said are legitimate. This is an area that's zoned residential and agricultural. It was not zoned for this, and we all live there, and we need to talk about how we're all going to live together. So we ask you for time that we can have these meetings, form this committee, have the ombudsman, and come back to this in a future moment where we can talk about this and find more harmony between these two groups. So we ask for some time. That we need time. There's neighbors that didn't even know this was happening. I've been informing the best I can and getting the word out, but we need more time. So I want to beg that you would consider that we are wanting to find harmony. We do want to find a way to compromise around this. We understand that we need this material, and this product is valuable, and there's no argument. They have the material now. This expansion isn't going to stop that material. This is just about us talking about the future. They themselves said 15 years is when they're going to start actually using that. So let's have another year to talk about it, please. Thank you.
Ms. Bang.
Sherry Main, same place, Riches Road. I wanted to correct a lady that came up earlier. I wrote this down and I forgot to say it earlier. Lisa Miller is on the planning board, and she recused due to owning J.B. Hunt stock, not Rogers Group stock. I wanted to correct that. And on the Springdale Quarry, she also recused herself for owning J.B. Hunt stock and owning property around the lake where that quarry is. And I wanted to ask J.P. Deacons, has he been to the meetings, the meetings that the quarry has? Has he participated in those and talked to the neighborhood? And does he have a direct communication with them, or is what he knows by hearsay or what other neighbors are telling him? Because he was very adamantly against this quarry, the Springdale Quarry, when they wanted to do the exact same thing there. And then, anyway, this was a campaign year, and you know, everybody gets some donations. So I'm just wondering, I want to know if J.P. Deacons is still thinking the same about that quarry as he did so adamantly when he was opposing it, when they wanted to expand the Springdale. What flipped his decision? It's not in his neighborhood now, but he has one in his neighborhood. And is he actively participating in those meetings that Hunt Rogers has with the neighborhood? How many people are showing up at those meetings? How often do they have those meetings? Just little feedback so we can know what to expect and what to ask for communication with Hunt Rogers. So that's a little concerning to me, is some input from him, since he lives in that neighborhood where that expansion happened. And again, I just want to reiterate, rules need to be followed, not only for the ones coming to asking for these cups, but the ones that are out here operating with smoke screens, actively working commercial red dirt pits under an agricultural exemption to grow strawberries. Really? I mean, it's a red dirt pit. They're hauling gravel out every day. Weddington Mine, Mitchell Massey is the owner. It's right on the back side of my house. I put up with it every day. They have 2 track hoes, a bulldozer. I went down there today and personally watched 10 trucks cycle in and out 5 times. That's 50 dump trucks coming in and out of there. They're hauling commercially to businesses, to new infrastructure going up. They're charging for that dirt. They're making money. It's not to his other places of business that he's hauling it to. So I want this tightened up. I want rules to be followed by everyone, and I want it to be fair across the board for the Lindsays, for the Terminellas, for the Mitchell Masseys, for everyone. I want them to go by the rules the same as everyone else and stop with the smoke screens. Thank you.
I'm still Jim Gallagher, and I still live on Martin Road. J.P. Pond, you talked about the one thing that you thought you could do something about. The one violation was the lights. You're looking to defend this in court. You've heard countless testimonies here about damage to property, damage to roads, damage to well-being, interfering with our use of our property. You have plenty of criteria. All you have to do is follow your own ordinance. I think it's very interesting, as was just pointed out, that when it was in your district, it was a problem, and it was a fight to the death. When it's in somebody else's district, we should be appointing this, and we should do it very, very quickly. This is just ridiculous. This is poor representation of us, the people who live here, the people who pay that $1 million in taxes, all for the benefit of the people who paid $19,000 in taxes. I know some of you got campaign contributions, and I know there'll be an ethics complaint in the morning if you vote. It's time for you people to be honest with the people that sit out here and do it. Do it the right way. Turn it down, please.
Just want to show this map to you again. This is not
Tell us who you are and where you live.
Terry Davis, Beaupre on Beech Nut Lane. This is not the only place in this 2-county region where a rock quarry can go. Again, 1,250 square miles of this stuff on the surface of the soil. It's weathered dirt from limestone. That means it's red clay on top and limestone right underneath it. This is a 3 square mile area where they're working in. Why can't they? There's all kinds of places where they can do this. Just because they've got a rock quarry there now doesn't mean that you should just give them a pass to enlarge it. It's ridiculous.
Public comments?
I think I'm naive. I thought part of the duty of the Quorum Court was to look out for the health, the welfare, and the safety of the citizens. And what I'm hearing from some of you tonight is that you're looking out for economic development and profits of an out-of-state business. We deserve better than that. You said that we should get along, talk to the quarry persons, get involved with the ombudsman program. We're not really interested in doing that. You don't ask a victim to confer with an abuser, and that is what we have endured for almost 2 decades. I plead with you, from your ethics and your morality for human beings and our lives, and you're going to choose economic development, rock is king. Please, where's the humanity? Help us. Thank you.
Public comments?
Ines Bardella. I live at 16235 Walnut Trace. I'm a resident for just the last 3 years. I've also been a family physician for 34 years. For 3 years, I've been hearing the complaints of the citizens and the impact on their health and their properties, as well as the concerns of the companies that want to expand. It's very clear to me that the negative impact has been great on the health of the people, on their property values, and on the community. I do understand the need to have the dirt and the products and the rocks. And I agree that there has to be a way to work this out. And I think the starting point to work this out is to hold the companies responsible. They're breaking the law. They're not following their permits. And you all are permitting that. So you as our elected officials, those at the county level, those at the state level, are allowing the companies to break the law and break the rules. And then they want to expand and you continue to allow that. That really has to stop if there's going to be a balance between ensuring the health and well-being of the citizens of their property and allowing growth and expansion in our region. Thank you. I'm asking you to vote against this. Thank you.
My name's Kiki Bernards. I live at 329 Railway Road. As the company has proven, they move into communities with little to no ordinances, and they say that they are following the law. And then communities come back and say, what can we do? Oh, Rogers Group, we followed the law. We are within these things. And all of these communities, it is too late for them. We are asking you to stop this before it is too late. We are right at the cusp of making a huge decision. If you say, oh, we can't stop it, we can't stop progress, actually, you guys can stop this for these people. You guys were put in this position so that you could protect these people. What are you doing to protect these people? There is more than enough aggregate in this entire community. There are quarries, as you have seen on the maps. There are quarries everywhere. There is rock everywhere. And all they are asking you for is time. If you approve it, then Rogers Group will go forward with no accountability. We know this. Statistically, they have nobody to be accountable to. So if you approve this just because you say we can't stop it, that's a fallacy. That's absolutely wrong. You should employ your consciousness and do the right thing for the people that you serve. Do you serve the community? Do you serve these people? Or do you serve the companies? Progress will still continue, but we need time so that we can put regulations in place. That is what we're asking for. We're not asking you to stop this. We're asking to stop the company itself. We're asking you for time so that we can have accountability.
Thank you.
Thank you.
Ms. Myra, this is item 13.1 to approve the CUP for item 13.1.
Eva Madison.
Abstain.
Robert Dennis.
Yes.
Suki Hires. Willie Lemming. Jim Wilson.
Yes.
Butch Pond.
Yes.
Lance Johnson.
Yes.
Shannon Marty. Sean Simons. Bill Usry.
Yes.
Patrick Deakins.
Yes.
Lisa Ecke. Sam Duncan.
Yes.
Chandra Washington.
Abstain.
Passed.
All right. Thank you, Ms. Myra. Item 14, Council, will you read that one by title only?
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board for Benton Auto Sales.
J.P. Lemming.
Thank you, Judge. I would not like to
Give me
take...
1 second, let me listen to the...
The girl in the white. Oh, I didn't see her. I like her too. I like her.
Turn it back in, because it may tie it to an inventory, because it may be a code number on it or something.
We
like
usually
that.
get people to turn their badges. I mean, you don't have to.
Or is there a little
They can
round?
go in and turn it off, but we usually ask for people. I take that back. Tara Stevenson asked if she could keep her badge, and I said, yeah, why not? And we still turned it off. So
Is it that little round disc thing?
It's a little gray bar. Yeah, it's a really old one.
Yeah, it's really
Yeah.
Like, I mean, I maybe keep that.
This is what I use every day.
Is it really old like Eva?
It's now it's not done electronic.
J.P. Lemming.
Judge, I wanna not take no actions on this. I need a little bit of time to talk to the people. I just need to go out. I went out and looked at it, and I wasn't satisfied with what I seen, but I want a little bit more time, so we'll just leave it on the first reading.
Leave it on the second, first reading, will be on the second reading in next month.
Thank you.
Council, go ahead and read item 15.
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board for the Brittenham office.
J.P. Pine.
Yes, I've had a conference with personnel at the planning department, and I've been informed that they had one neighbor lady that had a problem with this, and were able to settle with her with some, because she had some conditions they complied with, being a privacy fence. And so you might say there's nobody left that has any problem with this.
So are you gonna make a motion to suspend, or are you going ahead and let it
I
go?
move to suspend the rules and go to the second reading.
Second.
There's a motion and a second to suspend the rules and move to a second reading. All in favor?
Aye.
Those opposed? Council, reread that one for a second.
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board for the Brittenham office.
J.P. Pine.
Move to suspend the rules and put this on the third reading. Second.
A motion and a second to suspend the rules and move to a third and final reading. All in favor? Those opposed? Council, would you read that one for a third and final?
An ordinance ratifying a conditional use permit recommended for approval by the Planning and Zoning Board for Brittenham office.
J.P. Pine.
Move to pass.
There's a motion to pass item 15.1, a second by J.P. Wilson. Discussion? Any discussion, any public comments? Any public comments? All right, Ms. Myra.
Eva Madison.
Yes.
Robert Dennis.
Yes.
Suki Hires.
Yes.
Willie Lemming. Jim Wilson. Butch Pond. Lance Johnson. Shannon Marty. Sean Simons. Bill Usry. Patrick Deakins. Lisa Ecke. Sam Duncan. Chandra Washington.
Yes.
All right. Looks like that was good. Thank you, Ms. Myra. Item 16, Council, will you read item 16 by title only?
Is that the resolution?
Yes.
A resolution authorizing John C. Everett to solemnize the marriage of Jackson L. Diebold and Shelby Leanne Shelton on February 18th, 2023 in Washington County, Arkansas.
JP Willeming.
Mr. Everett just wants to marry his grandson. I want to, yeah. Marriage of his grandson. Thank you for correcting me.
Wow.
I'd like to put that
There's a
on the
motion
second.
and a second.
Yeah.
All in favor? Those opposed? All right, that.
Robert was the second.
Robert Dennis, and all in favor, then they, nobody denied, got it.
So
That
the-
resolution passed, so he can marry. Okay.
Marry.
Yeah.
He can preside the marriage of his grandson.
There were
Thank
no
you.
committee reports. County Quorum Court is adjourned.